So Lisa Kantor is one of the founding partners of Kantor Kantor Law Firm. And she has been in practice, I think, for over 20 plus years. Her main focus in her legal practice has been in the representation of individuals for health benefits that have been denied for treatment for physical and mental illnesses. She is a foremost leading expert in ERISA and insurance bad faith claims, and that is what Kantor Kantor Law Firm is about, is dealing with ERISA and insurance bad faith claims across the nation. Things like long-term disability, health, life insurance, long-term care. Those are areas that we have been focusing our practice on for years, and we're very successful at getting clients what they need. Lisa has received several recognitions and awards over the years. A few of them are coming from peers that are recognizing her for her abilities, which is a big deal. Lawyers that recognize other lawyers from places like Super Lawyers, Best Lawyers, top women attorneys in Southern California. So it's been a great career for her, and she's definitely deserved those well-reserved recognitions. Our esteemed guest panelist today is Andrew Kantor, and I will just stop really quickly and say, yes, there is indeed a relational connection. I'll let them discuss that. But I will say, Andrew has said it's very hard to grow up in a home where both of your parents are pretty powerful attorneys. It gets in your blood. His career at the law firm began as an intake director, and he knows a lot about how the law firm works, and he has been an attorney himself. Obviously, his area of expertise has been along the lines of disability for chronic fatigue illnesses like ME, CFS, and Lyme disease. Again, another highly sought out speaker. He's been on several advisory legal councils in his attorney career, as well as board members on nonprofit organizations. Currently, right now, he is focusing his efforts and energy as a director of operations at our law firm. So it's very exciting to see his managerial skills start to take off at the law firm. Again, he's had recognitions with Super Lawyers as a rising star. So you're really going to have today somebody here that's one of the country's leading experts on disability, as well as Lisa's expertise. So together, we look forward to whatever they're going to bring to the table. And with that said, I'm going to pass it off to you, Lisa.
I had to unmute myself so you can hear me. Thank you all for being here. It is just a pleasure and an honor to have Andrew here and talk about long-term disability. I'm going to turn it over to him very quickly, and he's going to give you sort of an overview the way I've been doing with health claims on disability claims, the good, the bad, and the ugly, and kind of some tips that he's gotten along the way. And I may interrupt him once in a while to ask him to clarify or ask him a question, but please do the same if there's something you want to hear from him. And so I'm proud to introduce my oldest son and the esteemed panelist, Andrew Kantor.
Thank you, Mom. I appreciate the introduction. We had a consultant years ago when my mother and I started working together, who insisted that I call my mother and father Glenn and Lisa. And I know I'm still supposed to do it, but it remains the weirdest thing. So I'll switch off referring to her as Mom or Lisa, but just know I would rather be calling her Mom. And while it was initially a little hard to grow up in a house with two powerful lawyers, it quickly became clear that I wanted to follow in their footsteps. And when people ask me what I do, the simplest thing to say is we sue insurance companies who don't pay claims when they're supposed to. And I was lucky enough when I started working for the firm to start working directly for my father, where he taught me basically all the ins and outs of disability law. And as Julie mentioned, the law ERISA, which is a federal law which governs all employer-sponsored insurance benefits. ERISA was a big theme in our law firm and a big specialty, which kind of applied to all areas of law and all types of insurance. So we'll talk about ERISA a little bit because I'm sure you've heard about it from my mother in previous webinars and how that impacts health claims. And the reality is it impacts disability claims a lot of the same way. But and currently what I do, as Julie said, I'm heavily involved with the management of the law firm, both because it's always been an interest to me, and it doesn't seem to be much of an interest to anyone else, especially when you have a group of lawyers. Mostly what they want to do is lawyer, and thank goodness for that. especially because the lawyers at our firm are all wonderful and they all like what they're doing. But when all the lawyers are lawyering, it does help when there's people to actually help manage the firm. So that's what I'm doing right now. I'm also helping basically supervise paralegals with the management of a lot of our disability cases, which have already been paid and approved. And so instead of fighting to get benefits paid, it's more of a consultation role, but that leaves me with constantly thinking about strategy and anticipation of how to handle disability claims. So while I'm not actively representing in any appeals like Carrie is, a lot of my work is still with appeal strategy. And I say appeal strategy, which is related to disability appeal strategy, which I'll explain shortly. So I'm really happy to be here and talking. I think the first thing to do, and I'm sorry this glare behind me will disappear shortly, I assume, is to make sure to differentiate what types of disability exist, what we are talking about, and what we aren't talking about. So when you hear disability benefits, first, the word disability means a bunch of things, and putting the proper definition for it aside, disability in this context is used as to describe the inability to work. So if you're disabled in this context, you are unable to work either full-time or part-time in some capacity. And there's different kinds of disability benefits available, just like there's different sources of health insurance coverage, both Medicare and private insurance. There are government sources of disability and private sources of disability. So starting with the government sources, the biggest one is federal Social Security disability. A large majority of people have that coverage just through the taxes they pay. There's some exceptions if you work for the government, but that's, again, a small exception. So if you ever become unable to work to the point where you can't do any work at all, one of the first things you would do if you remain disabled for a period of time is file for Social Security disability benefits. This is, again, offered by the federal government through the Social Security Administration. And it will pay you benefits if you are unable to do any gainful work for more than about $1,300 a month. So if you can't earn $1,300 a month or more doing anything, you can qualify for this type of disability benefit. Again, as I said, this benefit is offered to almost everyone who has worked for a significant period of time. I think I don't recall off the top of my head, but I think if you've worked for at least 10 years and you've been paying the taxes, you can almost be guaranteed to have it, but you probably have it if you've worked fewer than 10 years. And that applies to you regardless of what state you're in. The other kind of government-sponsored disability benefit is state disability benefits. State disability benefits only apply to the states that offer this benefit. It's only about 7 or 8. California is one of them, and California's is very strong. So if you're in California and you ever become unable to work, you should definitely look into state benefits quickly. If I recall off the top of my head, I think Hawaii and Washington also have state disability benefits, but it's a much more limited benefit. It usually only lasts for a year at most. In some states, it's only 12 weeks. But it's something to look at if you're, regardless of what state you're in and what state you live in and pay taxes in when you become disabled. So those are the government-sponsored sources of disability benefits if you become disabled. There are the type that, while we deal with these often and they interact with the disability insurance policies that we handle, we do not directly litigate either Social Security or state disability matters merely because they're so different. And it's an administrative process for both Social Security and state disability. And if Carrie gets a chance to talk, because she used to do Social Security litigation, the rules are just very different. It's a very different kind of engagement with a court. So there are lawyers who handle both ERISA or private disability and Social Security disability. But regardless, one thing I'll say right off the bat is whatever you do end up needing help with, make sure you find a lawyer that specializes in what you need help with. So if you get a Social Security denial one day, make sure you go and talk to a Social Security lawyer for it. And if you get a private insurance denial, which we'll talk about shortly, make sure you talk to a lawyer who handles private insurance. So private insurance is one of the other large sources of disability benefits. It's often provided by your employer, the same way health insurance is provided by an employer. It's not quite as frequent because I think a lot more employers offer health insurance than do disability insurance. But most people who do get disability insurance get it through their employer. If you're not sure if you even have disability insurance coverage, the first thing to do is check your pay stub and see if there are deductions being made for long-term disability benefits. Even if there aren't such deductions, your employer might be paying for it separately, so you can ask your HR department. But most people who have it are made aware in some form or another. If you do know you have it, you should, if you don't have a copy of your policy or plan document, that's one of the first things you should also do. Just like health insurance, there is a governing policy, which will also known as a plan document, the distinction of which doesn't matter right now, but either plan or policy document, which gives you all the rules and tells you when benefits pay, how much they pay, what the maximums are, what the exclusions, limitations are, and knowing all of those things is pretty much the first place to start. So if you're looking at a long-term disability policy, and first, our focus is long-term disability because long-term disability is long-term, meaning it pays till age 65 or 67 or somewhere in between usually, but it goes for an extended period of time. And I make this distinction to compare it to short-term disability, which, as I'm sure you're not surprised to hear, only lasts a short period of time. Usually short-term is between 0 and 6 months, and then 6 months and beyond is long-term disability. And I'll use long-term disability, and almost everything I say applies to short-term disability as well. And the only real difference usually is the timing. So you start with short-term and then it'll transition to long-term. Most people who have long-term and short-term, it's often administered by the same insurance company. Sometimes it's not, and you do have to make 2 separate claims. That's something to also ask your HR department about. But before we get into too many of those technical procedural details, big picture, while every disability policy is technically different, most private disability policies are broken down into 2 major parts. The first 2 years and then the period thereafter. The first 2 years is the first benefit period, and these disability policies will pay you your benefits if you can show for those first initially and then for 2 years that you are unable to perform the material duties of your own occupation. Now, you might be asking, well, wait, why isn't he just saying if you're unable to do your job? Because unfortunately, they mean 2 very different things. The inability to perform the material duties of your own occupation, as defined by insurance companies, doesn't necessarily mean your inability to do your own job or your own job title with your particular employer. It means the inability to do the job as it's pretty much defined on average by the average employer who holds a particular position. And there's a varying degree, additionally, of how specific they will get when defining your job. So depending on your policy, an office administrator might just become a manager, where there's different job duties that you might require in your job that someone else might require. The insurance company might define it differently. So it's important for you to understand that distinction if you ever make one of these claims. So beyond reading kind of the language of how it just, let me slow down. So after those first 2 years, after that first hurdle, the second part is any occupation, which is called the any occupation standard. So if for the first 2 years, benefits are paid if you are unable to perform the material duties of your own occupation. After that, you have to meet an additional burden, which is showing that you are unable to perform the material duties of any occupation. And so most people, when discussing these policies with me, this is surprising initially because most people think the policies will basically pay you permanently if you can't do your own job. But this distinction is really important depending on what your job is. And so the way your job is often defined is broken down by strength category. So a office worker may have a sedentary job, which doesn't require a lot of physical exertion. A warehouse worker might have a heavy job. So if a warehouse worker injures their shoulder and prevents them from lifting 100-pound boxes, they probably can't do their warehouse job. And if they can't do that for 2 years, the insurance company will almost certainly pay the benefits. But regardless of how long that shoulder is injured, after those 2 years, the insurance company will then ask, okay, we acknowledge you can't do your own job as a warehouse worker. Are there other occupations you can do that would pay you roughly as much as you were making before that you could do despite your injured shoulder? And if you're a warehouse worker, what the insurance company would say is, oh, you can potentially be a warehouse clerk where all you have to do is computer work and it doesn't require you to lift 100-pound boxes. This often requires job retraining. It can require a lot of different things. And the reality is the job may not even exist. But the insurance company will create this kind of theoretical standard after those 2 years and see if you meet it. So for the people who have claims going on for a few years, you have to make sure that you're either looking forward to those 2 years or your medical evidence supports your inability to do any job. And we can get into more detail on that shortly. So the basics are, for the first 2 years, if you can't do your own job or your own occupation, they'll pay benefits. And after that, if you can't do any occupation or any job, they'll continue to pay benefits until age 65 or 67.
Hey, Andrew, can I ask you a question?
Always.
On that? So I know a lot of times you deal with people who are in the first 2 years, and there's something that's challenging them to do their job, but if their employer were cooperative and sort of accommodated them, maybe they could do their job. So like I can think of an example recently where someone was having hand problems and they were typing. Their job required typing.
Mhm.
And so they wanted to know from us, do I have to ask my employer to get me a program where I can speak into my computer? And if I don't do that, am I not disabled? Can you talk about that a little bit?
Yeah, absolutely. So accommodations and the way accommodations from employers fit in can be an important part of these claims. So the reality is, if you don't seek accommodations at all, so let's use your example. If you've got hand issues and your job is all typing, right? And you have broken hands, let's just say, make it really easy. And you just file for disability without seeking accommodations, you leave room for the theoretical argument from the insurance company to say, you didn't seek accommodations. If you had, the average employer would have accommodated you and allowed you to work. Now, if the accommodations we're talking about, someone who has back issues is asking for a chair to sit while they're while they're checking people out at a checkout stand, that's a reasonable accommodation, giving someone a chair, right? If that's all they need, you need a chair. Most employers, I really hope, will give you a chair. The example you use of Dragon Speak is a really interesting one. It's kind of unique because, and I don't know what would happen if this technology were perfect.
Mhm.
And someone could actually use it the same way they could use a keyboard and not lose efficiency and not lose their minds. Because I've tried it and I've lost my mind to try and use that technology. There's an argument that would be a reasonable accommodation, and the average employer would accommodate that. Thus, you are able to do your occupation as it's normally done for the average employer. And so it becomes very fact specific. One of the big issues that's coming up is remote work, and how much remote work is a reasonable accommodation from the average employer. Now, the insurance companies are always 10 to 15 years behind everything, with everything they do. So they're going to start making this argument in like 8.5 years, maybe 9 years. But they're eventually going to start trying to argue that, oh, we know you're really disabled, but you could work from home, and this job can be done from home, and thus you're not really disabled according to this policy. I don't want to say I'm eager to take on this argument because I don't want anyone to get denied on those bases, but I think the insurance companies are going to really have to put themselves out there to be able to differentiate what is and is not remote work. Like, for example, my job at my law firm as an attorney can be done remotely, largely because we're rarely in court, and a lot of what we do is writing because of ERISA, and a lot of our clients are homebound. So we go to, we either talk to them via Zoom or we talk to them on the phone. There's no need often to be in court or an office presence. A criminal prosecutor would almost have to be in court every single day. And so I don't think, at least, they could do their job remotely. A criminal defense attorney certainly couldn't, because they have to be in jails. So the difference, even within one occupation, of what is going to constitute the average employer, it's really hard to say, especially because the insurance companies use statistics and information about jobs that was originally first sourced in the 50s, barely updated in the 70s. And the Social Security Administration still uses a lot of this really old stuff. So they kind of like pick and choose what they want to use and not use. And it results in this weird amalgamation of standards that doesn't even make that much sense in the common context. I can't count how many denials where we've had to explain, yes, we understand the person can sit at a desk for 8 hours, but they're cognitively impaired, so they can't do any work while they're sitting there for 8 hours. So they can't do a job, but there's no evidence that they can't physically sit there for 8 hours. Like, we have to explain, because it's 2023, that jobs require brain power, and the ability to just sit in a chair doesn't mean you can work.
Wow.
And so that, there's a lot of nuances that often become really fact specific if you're looking at a disability claim. So it's really important to if you get down this road, I mean, this is kind of far down the road, to talk to someone who knows, hopefully in your state, if possible, how to handle the claims you're dealing with. And, to kind of back up a little bit, to make sure we're talking about the policies from a 30,000 foot view, there are certain aspects of these policies which, if you're even investigating them, you should pay attention to. So one thing, because we're a health insurance crowd, I can discuss right off the bat, is pre-existing condition limitations. I don't think there's any dispute that getting rid of them in the health insurance context was a wonderful thing. People deserve to have health insurance whenever they can. And I think the reason they're in there in the first place was the ideal of, we want to prevent gaming of the system, where people don't buy health insurance until they really need it. And then when they really need it, they buy it, and then they can get all the care they need, instead of being forced to buy it when they're healthy to help contribute to a healthy system. But we all agreed it was more important for people to survive and actually get health care than to punish them for that. And that's a great thing. But the logic still applies and is still effective in disability policy. So disability policies still have pre-existing condition limitations. And they are all pretty much, and I explain the theory first because it kind of makes more sense to understand it if you understand the theory. They're really designed to prevent gaming of the system, to prevent those very few bad actors who for whatever reason, they know they're unable to work. They get a job for the sole purpose of getting disability coverage, and then, a few days later or a week later, turn around and file for disability with no intention of ever working, right? If everyone could do that with disability insurance, nobody would have disability insurance. And, I'm the plaintiff's lawyer saying that, right? You can't allow just everyone to game the system like that. So most policies, almost all policies, will still have a pre-existing condition limitation, which it obviously catches people who are not trying to game the system, especially now that COVID exists and MECFS. But the basic structure is that if you file your claim within a set period of time of gaining the coverage, which is usually a year. So if you file your claim within 12 months of your coverage starting, you are automatically subject to a pre-existing investigation, which will thus look backwards to the usually 3 months leading up to the coverage starting, and see if any care, treatment, services, or medication that you received during that 3 months is connected to what you're claiming disability for now. And you have to look at your policy, because there's a lot of really nuanced distinctions in how these pre-existing policies are worded, which can be really important. Some of them include medication, some of them don't. So if you've had a condition for 20 years that's never been disabling, that you've had, you take one pill a day for it and it's managed, and then all of a sudden COVID hits and transforms it into something disabling, the difference between, if all you've done is take that pill, the difference between medication being in that language and not is the difference between your claim being paid if you're filing it within a year. So that's one thing to be mindful of if you're looking at the policy. Is 99.99% of them, I don't think I've ever seen a policy without a pre-existing condition limitation in it. You can almost be guaranteed there is one in there. And if there's not, I'd honestly, if you're going to file a claim in that period and you don't see one in there, I would almost reach out to my employer to make sure, because I'm genuinely, you probably have the wrong version of the policy, because they're almost always in there, which is not the case for all these other things I'm going to talk about. So that's what you want to look at right off the bat, especially if you're someone who's going to be filing a claim within a certain amount of time of your coverage starting, and be mindful of the difference between your coverage starting and your employment starting. Most of the time your coverage will start automatically as a result of your employment. That's not always the case. For sometimes you have to opt into coverage, and if you don't opt into coverage until later, your coverage date doesn't start till later. And if you apply for if you select an optional increase in coverage, the entire policy or the portion of the buy-up, so we call it, that additional amount could be subject to the limitation if you've bought it later. So it's really important to know when your coverage is effective. You usually get a letter saying your coverage is now effective as of this date. And if you're not sure, again, you can ask your HR department. So
I have another question. Yeah.
Yep, please.
So do we, I don't actually know the answer to this question. Do the disability lawyers at Kantor Kantor, are they willing to talk someone through this problem? I mean, I think of myself. So, I carry a diagnosis of MS.
Mm-hmm.
And there's been times when I've taken an MS drug. And so if I were looking to get, I'm too old, very old, as you all know. I keep saying how old I am, but not qualified for disability anymore. But if I were in that situation, could I go to someone at Kantor Kantor and say, okay, here's what my diagnosis is, here's what I've been doing, here's my policy. Can you help me walk through, when am I safe to go out on disability if I feel like I can't work anymore?
Yes.
Okay.
If there's if you're at the point where you want to file a claim and you're not sure if you're subject to it, absolutely. But if you're just saying, theoretically, if I file today, what if I file tomorrow? The reality is, if you read the policy, if you're filing after that 12-month window, you're fine. You're clear as far as the pre-existing limitation goes. You just have to know when your coverage starts and what that day actually is. So I'm tilting this.
Interesting.
Avoid this craziness.
Yeah.
So yeah, pre-existing condition limitations are big. And if you are worried about this, and you actually are thinking of filing a claim, one of the first things I tell pretty much everyone, and really what we need to make the assessment, is all of your medical records from the 3 months or 6 months if it applies, but from that 3 month window, as well as the medical evidence related to your disability. And usually there's rarely a dispute about the disability related evidence of today. It's the disputes are usually, and the litigation is usually about the contents of what is in the records leading up to the denial, those 3 months. And please don't assume, I'm sure that this group knows not to take an insurance company at its word. But the insanity level of the egregiousness and just the nonsensicalness that they will uphold as rationality in the form of a denial is the same in every ERISA insurance industry. Like I'm sure you've seen denials where you just want to either like rip the paper apart or laugh at how absurd it is. I just had one denial where, the insurance company said, yeah, we understand that this person has right wrist and left wrist necrosis and can't use their hands, but they haven't seen a specialist for it yet. And there hasn't been a specialist to write down exactly what they can and can't do with their hands, even though they've said they can't use their hands because they have bilateral necrosis in both of their wrist joints. Because there wasn't a box check, we're just going to deny it. And it's like, because it's ERISA, they're not worried about being sued for bad faith. And so not only is it egregious, the same guy who signs this particular medical report has signed at least 40 in our system alone, because we can cross-check it. We have 40 active cases where this one doctor signed the same ridiculous variation of a conclusion. So the fix is in, same way with disability, ERISA sponsored disability insurance. The same way it is
Andrew,
insurance. Yeah.
Before you go on, I missed this question. Angel had a really good question about accommodations.
Mm-hmm.
The question is, must the accommodations after 2 years be with the same employer? And I think you're asking, do you have to get the same accommodations after the 2 years with the same employer? Is that
so? No.
okay?
At no point does anything necessarily have to be the same. And I think I'm not exactly sure specifically what you're asking, because I have 4 questions which my answer applies to. So hopefully my answer applies to one of them, where you're never locked into anything. First, when you file your claim and become disabled and stop, let's assume you stop working full time. if you're permanently disabled, your employer will eventually terminate your employment because employers are not required to keep you employed, and most of them will terminate your employment and expect you to get health insurance via COBRA at some point. And that does not at all impact your claim. So just because your employment is terminated, all that does is prevent you from filing another disability claim as of that day. Once you're fired, you can't file new claims, but the claim you filed as of the day you're still employed remains active. So you keep getting paid regardless of your employment status. So that's one thing to keep in mind. Because I get a lot of calls of people really anxious that their employment status, they're about to get fired because they haven't worked for 6 months, 9 months. And they think that their disability benefits end, but that's not true. So the whole point is, as long as you are covered when you make your claim and whatever disables you at that time and you remain disabled because of that, you keep getting your benefits regardless of your employment status. Now, most of these policies will also pay you even if you're not fully disabled. So many will pay if you have to reduce to part-time. Many will pay if you don't even have to necessarily cut your hours as much, but if you suffer a significant income loss, if you have to stop being a lawyer and you have to become a yoga instructor because the stress is killing you, but your salary gets cut in half, even if you're still working the same amount of hours, you still get to file for disability if you have a disabling condition which prevented you from being a lawyer. And that's another thing people don't often understand is it's not just about, if I can do anything, I can't file for disability. There's a lot of different levels which you'd be entitled to benefits. Some people just cut their hours in half and their employer, pays them half salary and they maintain their employment on a part-time basis and the benefits keep going. Now, if you get accommodations for the first 2 years, let's say I'm a lawyer and I get accommodations for 2 years. I get the dragon speaking for 2 years, and I'm able to work with that for 4 hours a day. If I'm working in that occupation for 4 hours a day, the way the any occupation standard applies will depend on the wording of the policy. So if they've acknowledged I'm disabled under the own occupation standard on part-time basis, they now might say, well, you don't qualify for disability anymore because you can do another occupation full-time, even though you can only be a lawyer for 4 hours a day. And accommodations play in as far as, what other job could I potentially do? If you can get accommodations to do another job part-time, they might be right. And if you can do that, you might, if you're still working part-time, there's even more of an income loss you could claim. So but don't ever feel like you have to, just because you got accommodations that got you paid initially, if your accommodations have to change, they get worse, they get more stringent. And what happens to a lot of people is, your employer will support your accommodations for 4 months, 5 months, 6 months, and then for whatever reason, they can no longer do it. Like it wasn't a permanent accommodation that was structural, it was a temporary accommodation, and then it just disappears and they decide to no longer support it. You often will become eligible for benefits then. And so the insurance company can technically say, well, your employer didn't accommodate you, but a different employer would have. That's not an argument we see a lot because once your employer doesn't accommodate it, that's the default assumption, right? Okay, well, if your employer is not going to accommodate it, what's to think a different one would? So they then have the burden to kind of show why your employer is uniquely hard on you and why another employer would sustain, would support you with accommodations. So it's not an argument we see very often, at least in that context. But I think the bigger kind of takeaway, you definitely want to try for accommodations, because if you skip that step, you leave yourself open to them saying, because you didn't try for them, you don't know, you could work with accommodations basically. And it's not a great argument for the insurance company, but sometimes they don't want great arguments. They want to throw whatever sticks and hope you go away. So before I move on, are there any other questions about accommodations? Because I want to make sure if there are, I address them. Doesn't look like it.
Okay.
So again, if anyone has any questions at the end or later, you can reach out to us and we'll answer anything. But as far as going back to our theoretical disability policy that we're all looking at and reviewing, so we know what rights we have. After the pre-existing condition limitation, which hopefully doesn't apply, once we decide it doesn't apply to us, you want to look at the other limitations in the policy, and the pre-existing condition exclusions are distinct from the policy benefit limitation. So a pre-existing condition exclusion, and if I didn't say exclusion before, I should have, and shame on me, because it excludes your right to get benefits under that disability. So if they say your disability from now is connected to before and you fall under the policy, they will not pay you anything that is allegedly related to that disability. There are separate from that are distinct benefit limitations which exist in various forms in these policies. So the one I deal with almost by far the most frequently is what they call mental nervous limitations, which are basically limitations based on disabilities that are due to mental health issues. If you're disabled from anxiety, depression, schizophrenia, anything, which is sometimes they literally say anything in the DSM-5, your benefits are limited usually to 2 years. There are not always mental nervous limitations in the policies, but very frequently. The higher paying your job is and the more stressful your job is and the more specialized your policy is for your job, the less likely there is to be such a limitation. So if you're a partner at a law firm making $500,000, chances are there isn't a mental nervous limitation, because if you're, because mental health limitations really impair you and you need to be, there's a bunch of reasons. But if you have, let's say you work for Kellogg or Intel and you're one of their 20,000, line workers, I can almost guarantee there will be some kind of mental health limitation. So once assuming you've found the mental health limitation and read it, there's a few important things to pay attention to. First is that this limitation, like the other limitations I discussed, there'll be critical language that can change basically the dynamic of the case. So limitations can be worded so that they don't pay if your disability is due to a mental health issue, or they cannot pay if your disability is caused or contributed to by a mental health issue. And there's a bunch of different variations in between. But lawyers, if you go to a lawyer, we will ask about that, because it changes the burden of who has to show who is disabled by what. And I can kind of gloss over why that is, but I'm sure you can extract it. If the language requires a different obligation on part of the claimant, and so sometimes you have to show that you have to affirmatively show that your physical issue is what's disabling. Other times you just have to show you're disabled and not exclusively disabled by the mental health issue. And it's something that, too much depth on one particular topic that you should call us for anyway. But another thing to look at is exactly how it's crafted. So some of these mental health limitations are blanket limitations on any diagnosis which falls under the DSM-5 for any cause. So regardless of if you have severe cognitive impairment, or even Alzheimer's, the policy will not pay you. If you have severe cognitive impairment caused by a blow to the head, the policy will not pay you, which to us is one of the most egregious things we've ever seen. The whole point of a mental health limitation is for impairments that don't have a physical cause that we can all verify via evidence, to limit the amount of people who can just say, look, I'm disabled from depression, but there's no test, you just have to believe me. That's their argument. But when you get hit on the head with a baseball bat, it's not the problem. So the way these limitations are worded can be really broad, or they can be a lot more narrow. They can say they can exclude certain conditions or only include certain conditions. Some limitations will say mental health issues only include depression, anxiety, schizophrenia, and those are the three I'm remembering right now. Borderline personality disorder, and they'll also explicitly say bipolar is not included on this list. Cigna and New York Life policies, or now New York Life, are famous for excluding bipolar disorder, saying that it's an organic brain disease and not a mental health limitation. So make sure when you're looking at this limitation, pay attention to how it's crafted and what if it has exclusions within itself. So sometimes it'll say we won't pay you if this, but if your mental health issues is one of these things, then you're absolved and we'll, continue paying.
No,
So
I
it's
have a
based on the
question
order.
about
Yeah.
that. So what would you advise people who, let's say, I'm trying to pick something that's fibromyalgia. Okay,
Mhm.
well, fibromyalgia is a physical disease, but
Yeah.
it's often associated, because it's such a difficult disease to deal with depression or anxiety.
Yeah.
I mean, I'd hate to see people not going to a therapist or psychiatrist, but do they threaten their ability to get more than 2 years when they are seeking treatment for the side effects of their fibromyalgia?
So one piece of legal advice I can effectively give everybody is that if you need mental health help, go get it.
Okay.
Please do not avoid mental health treatment because you're worried about an insurance company limiting your claim unfairly. I give this advice for several reasons. First, I think it's the ethical thing to do, and more importantly, from the disability lawyer perspective, who's actually advising you on these things. If we're talking, from a strategic perspective, first, a mental health professional is the best person to say you're not disabled from your mental health issues. But who better to say, yeah, I see this person every week, and the mental health professional is also the best person to say, yeah, this person has consistently said they weren't depressed before they got fibromyalgia. And a lot of the ways these limitations are crafted, even if it's not explicit, if the depression, if the mental health issues are caused by a physical illness, there's no room for them to limit it. And even if it doesn't say that, they know that. And you're in a much better position to get treatment for what you need, even if they decide to try to try and waterlog you and make it an all mental health issue. Not having mental health support is not going to help. Having mental health support to argue with them because they're going to have a psychologist, psychiatrist, review the records and argue, oh, this is why I obnoxiously can conclude that this is a mental health related issue. And so your experts are the ones who need to come back at them. And often when people, first of all, regardless of your physically disabling condition, most people who become disabled have mental health issues as a result. People don't like being disabled. I don't care what the crazy propagandists say, the anti-disability people say, being disabled is not a sitting on the couch all day, eating bonbons, enjoying the good life. It's insanely, you don't get paid your full salary. It's insanely hard to go to all these doctor's visits. You pay out of pocket for a bazillion things, and you're constantly worried about getting cut. I mean, I know better than anyone, as much as my clients do at least, that it's not fun being on disability. No one fakes it. They do it because they have to. All of my clients, by a large, indisputable degree, if they could be working, they would be. They could be working part-time, they would be. And it's one of the reasons I really like my job is because, all of my clients are like that. And so, but I almost got off track. So with the, what was it?
You were talking about getting the treatment, why you should get.
Right. So
Yeah.
there is, the reality is, one of the reasons a lot of our cases are, it's the insurance companies are arguing a position that's untrue. We have the truth on our side. Our clients are genuinely disabled. They come to us saying, I can't work, and the insurance company says I can. What the hell am I supposed to do? And thus there have to be holes in that argument. So I say this because if an insurance company decides to waterlog you and try to literally put everything in that basket, they have to make mistakes. There have to be holes in their argument. And often it's just a matter of, finding the right kind of evidence to counter them. And depending on what disables you, physically, this is actually a good segue. There are different ways to kind of prioritize your claim. So there are certain physical ailments that are easier to prove than others. So regardless of the diagnosis, and one thing I'll comment on is outside of the pre-existing condition issue and the mental health limitation issue, the diagnosis doesn't usually matter. As long as it's agreed that it's a physical diagnosis, no insurance company is going to care the difference between fibromyalgia and Sjogren's disease if they're both causing physical issues. As long as it's physical, the impairments are what's focused on. And at the same time, regardless of how severe your diagnoses are, diagnoses alone do not mean disability. So, one of the most outlandish cases I've ever seen is a famous story my father likes to tell about, a case where a client had Parkinson's disease and basically lost in trial because I have Parkinson's disease, pay me. And they didn't do the basic forms. They didn't give the basic evidence. And hell, I honestly think someone should be able to say, I have Parkinson's disease. Here's the test, pay me. I genuinely think that should be enough. But the reality is there is still an obligation on the person to show that you deserve the claim you're filing for. You actually deserve, that you actually are entitled to the benefits. So don't think that just because you have the diagnoses, that's going to be enough. Your medical records have to support it. You also usually need at least one provider to certify your disability. Ideally, that means a doctor who genuinely believes you're disabled and agrees with you and your limitations and is willing to fill out the precise detailed forms that the insurance company asks you to fill out. This is a great thing if you can get it. Just because you can't, don't feel that you're completely out of luck. First, everyone who has Kaiser out there, I'm sorry that all your people are going on strike like today. That's not looking. We're gonna get, I think, calls about that eventually. Kaiser doctors often refuse to comply with these things because allegedly they're not allowed to. There's corporate rules, and I shouldn't single out Kaiser and other large similar-ish organizations are more likely to have rules which say our physicians cannot sign these disability forms. Ironically, it's based off of a fear of nothingness, because ERISA claims there's literally no way for these doctors to ever become liable, yet what are they afraid of? We don't want to go to court because we say someone's disabled and they're, not. I really haven't gotten a good explanation. The reality is doctors are afraid of lawyers, and so whenever I try and talk to them, they scurry and get freaked out. So the reality is, it's great to get that doctor who's in your corner and is willing to sign things off. If you can't, there are disability insurance companies who will give you a hassle, but you should be able to get your claim paid if your medical records alone are good enough. If you can kind of put together the support, if the support exists in your records, yet you can't get the forms you need, that should be enough. You just may have to do the legwork of highlighting where it says in your records, this is where the doctor says that I can't be out of bed for more than an hour a day, or I can't lift anything heavy. Because sometimes you don't spoon feed it to an insurance company, they'll say, oh, well, we're missing this checkbox, so we're going to deny you. And you can go through the hassle of suing us and appealing. So
I know too that, Andrew, there's I think, and maybe we have like 5 minutes left. There are some tricks or things that you've done, or Kantor and Kantor have done, when there's not what we consider to be stellar doctor support. There's kinds of things that we can do or advise people on what they should do. And maybe if you could take a few minutes to just run through some of those ideas so people have people know. Yeah.
So if your doctor support is not stellar, and also assuming that your medical records don't reflect what you need from your doctor, which happens a lot, there's a few things you can do. So first, it depends on what's impairing you. There are different, as I was kind of saying before, I'm glad we're back on this. There are different physical things that can stop you from working. Some of them easier to prove than others. There is pain, fatigue, cognitive impairment, side effects of medication, generally mental health related issues, and other things that can all impair you and stop you from being able to work for different reasons. Migraines is another, pain from migraines is a kind of a specific one that acts as a good example on one end of the spectrum. Migraines are, for anyone who has them, they can be extraordinarily disabling, and they're some of our best and toughest cases, best from my perspective, because I mean, these people are suffering so much, and there's so much evidence of their suffering, but there's no test out there that can prove migraines. So, basically, no matter what someone does or says, I mean, imagine the biggest migraine sufferer you ever imagined, and what kind of doctors they'd see, what they would try, over the counter stuff, no matter, what medications they would try from their doctor. The insurance company can look at all of that and say, yeah, we understand you get migraines and we understand they're impairing, but there's no proof that you're actually unable to work as a result. Like, why can't you be the person who just like trucks it through a migraine every day at your office, and that's compared to kind of the other end of the spectrum, which is clearly confirmable and identifiable ailments. If you say you have severe wrist pain and you can't lift more than 10 pounds, and you show an x-ray of your wrist bone being shattered, no one's going to dispute that you can't lift with that wrist. And so, if you're the person with the broken wrist who's the warehouse worker, and your doctor won't sign the dang form, and for whatever reason you can't get copies of your x-rays, or it's something like that, you can either see another doctor. There's nothing wrong with trying to find someone else, paying out of pocket, and if it's really good, starting care with that other doctor. And then if the insurance company ever asks, which they rarely do because the medical records usually speak for themselves, you say, my first doctor wasn't filling out my forms and my records weren't very good. I needed a doctor who could document my disability properly, and I found a much better doctor, so I switched. And they don't usually question those things because it's clear why you switch. So you can get a new doctor. If there's ever errors in your medical records, and that's one of the reasons they're not supportive, you should be able to fix that. But I mean, this group would know that as well as anyone. But you should be able to fix anything inaccurate in your medical records by just calling them and asking them to. There's also independent tests you can do. If you're physically impaired, there's something called a functional capacity evaluation. If you're cognitively impaired, there's something called a neuropsych evaluation. If you get to that point, call us first. If you are disabled and about to make a claim, I suggest you request your medical records before you file any kind of claim to see what's actually on there. But if you realize your medical records don't show what they need to show and you're about to file a claim, call a lawyer first, because that's the period where we could really give you some critical guidance. And the reality is, one final thing, if let's say you're cognitively impaired, and that the best test to prove cognitive impairment is a neuropsychological evaluation, and you have a treating neurologist, and you say, hey doctor, what about this neuropsychological report? And the neurologist says, well, I believe your subjective complaints about your cognitive impairment. I don't need this test because the test is to verify how bad it is and the source, but I believe everything you're saying, and from that I can make a reasonable evaluation. All this would serve to do is confirm what I know you're being honest with me about. And so thus, it's not medically necessary for a lot of people. However, for some it is, and because they use it diagnostically, because they're not sure what's causing the cognitive impairment. However, if you get a test like that through your medical insurance, you can pretty much assume your disability insurance company is going to see it, regardless of the outcome. And while that often isn't a problem because it's something you end up submitting anyways, and you submit your medical record anyways, these big ticket tests like a neuropsych evaluation or a functional capacity evaluation can be such game changers. And there's an error rate where they sometimes don't find what they're supposed to find, and it's not even necessarily unhelpful. Sometimes the neuropsych can't validate your cognitive complaints because of mental health complaints, and so it can be indirectly helpful. But regardless, you want the ability with these huge pieces of evidence to decide not to submit it if it doesn't support your claim. And it's a rarer thing, but it's not so uncommon that I don't talk about with people a lot, especially people who have nuanced issues that sometimes only come on after a few hours, or they're related to fatigue. Sometimes these tests just don't capture those things. And if you have if you don't have the right evidence, your case is tough. If you not only don't have the right evidence, and you have evidence that helps the insurance company, your case goes from tough to arguably unwinnable. So to have a neuropsych evaluation like that is unhelpful, and the insurance company gets it, it can kill your case when your case shouldn't be killed, basically, when you should still have that chance to submit different evidence or to emphasize other parts of your claim when you really can't work, especially for multiple reasons. So be mindful, if you're ever offered something through your insurance, the disability insurance company is eventually going to see it. The alternative being you can ask to pay for it out of pocket, get the same test from a different provider, or contact us. And if we are representing you, we would pay for it and advance the cost at least. But we hopefully can help you do whatever you can to not need to hire us before you do. Because if we help you with everything we can and you still get denied, then we know you do need us. And unfortunately, that's what we're here for.
Yeah,
that's why we exist, for those bad situations. But
that's a good place to stop, because we're a
time.
little bit over, and I'm sure Andrew could keep talking for hours on this. I told you it would go really quickly.
Only being over 1 minute is pretty much a record for me. I mean, at
Yeah,
least
I know.
being over it's kind of a 15-minute thing by default. So I take this all as I value your time very much, as much as I value yours.
Thank you all for being with us. As always, email Andrew, email me, email Julie if you have any questions. We're happy to talk to you individually about issues that you might have. And thank you, Andrew, for appearing. I know it's a lot of information for you guys to process, but hopefully he'll come back again in a couple of months. And I hope you all have a great week. Thanks for being here.
I love a captive audience. I'll come back whenever you ask me to.
Sounds good.
Thank you all.
Bye, everybody.
All right, bye-bye.
Bye.